Are you able to hear me on the audio? Thank you so much. Mask off, because clearly that seems to be helping right now. All right, good evening. I appreciate your patience today. My name is Tracy Marshall, and I'm the Division Director for the Division of FAMLI at the Colorado Department of Labor and Employment. FAMLI is an acronym standing for the Family and Medical Leave Insurance, and I want to welcome you all to this first rulemaking hearing for the new division and time is 5:06 p.m. on Wednesday, November 3rd, 2020. Recording of this hearing will be added to the administrative record for these rules. Again, I thank you all for joining us. The following division officials are with me at this hearing, some of them in person and others remotely. I have Vanessa Castorena, Executive Assistant to the Director. Manager and today we will accept testimony on one set of proposed family rules that were published in the Colorado Register as proposed rules on September 30th. I hear that we're having Okay, let's try this. Again, if you're struggling with the audio, and we'll keep working through it. Okay, thank you. All right, so today we will accept testimony for one set of proposed family rules that were published in the Colorado Register as proposed rules on September 30th, 2021. The regulations concerning paid family medical leave program related to premiums 7 CCR 1107-1. Anyone may speak on this rule. We will not be taking testimony on other family policy topics that are not part of these proposed rules regarding premium collections. For all rules from this division, the notice of public hearing and associated rulemaking documents were filed with the Secretary of State for publication on their website and in the state register as provided by the Colorado Administrative Procedures Act. We are recording the hearing and will post the recording on our rulemaking page by close of business tomorrow, November 4th. That page again is famli.colorado.gov, famli.colorado.gov. On the off chance that more time is needed or if we have technical difficulties, this hearing may be continued to another date, which we will announce at the end of today's hearing, with details posted on our webpage by noon tomorrow. Finally, while to date we have not received any RSVPs or other indication that anyone wishes to speak in person this evening is in need of language accommodations, please let Vanessa know if you need an accommodation, and we will do our best to locate a resource.
Buenas tardes, mi nombre es Vanessa Castorena, soy la asistente ejecutiva de Tracy. Hasta la fecha no hemos recibido ninguna confirmación de asistencia u otra indicación de alguien que desea hablar en persona esta noche. Si alguien necesita adaptaciones lingüísticas, infórmeme a mí personalmente y haremos todo lo posible para localizar un recurso. Gracias.
Thank you, Vanessa. Once again, thank you for taking the time to attend this public hearing and to participate in our rulemaking process. We will now proceed with oral testimony. We will start with those who signed up to testify in advance, starting with those here in person, then those here by computer, then those here by phone. Then we'll invite testimony from those who did not sign up in advance, but who have signed at the registration table at the front of this hearing room, who are here in person, followed by those attending by computer, and then those here by phone. Before we begin, a few instructions for participants. Please keep your computer or phone on mute. If you are testifying, still keep your phone on mute until we call your name. For those speaking, when we do call on you, please do the following things. First, please unmute yourself. And then when we remind you that you forgot to unmute yourself, please do unmute yourself. Please state your full name, your job, and your role, and whether you are speaking on behalf of any organization. Please speak in a clear, slow voice. We may interrupt to ask you to repeat anything we think may have not been heard or that we think may not be audible on the recording. Please remember that testimony is limited to 3 minutes. If you wish to remain anonymous, that is your right under the Wage Protection Act Rule 4.7, and you can say your first name or a fake name or just describe as much as you are comfortable as to your role, your experience, or the experience you are here to testify about. We know many of you have more input on these rules than 3 minutes of speaking can cover, and that is why we've been soliciting written comments for months and will continue to do so until 5 p.m. this Friday. Also, if you have more to say than you can cover in 3 minutes of speaking, you can submit the rest as a comment either by writing it at the table at the back of the room and dropping it in the box if you are here, or by emailing to Lydia Wologorski at state.colorado.us. That is Lydia, Lydia .Wologorski, WALIGORSKI at state.co.us, or by using our Google form to submit written comments. If you would like to give your name and information for the record, whether you testify or not, or if you are on the division's stakeholder list and would like to be sent notices of proposed rules or other family publications, you can email Lydia Wologorski at lydia.wologorski at state.co.us after this hearing, or fill out any of the division RSVP forms on pages linked from our rulemaking page, which again is family.colorado.gov, and under the News and Events page, which can be found in the top page navigation from the Colorado Department of Labor and Employment, commonly referred to as CDLE website. Thank you for your interest in and your participation in these important matters of Colorado labor law and policy. The division will post all rulemaking documents on our website and publicize them to our contact list of stakeholders. For more information on any of these proposed rules from this division, whether the rules covered at today's hearing, visit the division's rulemaking page at family.colorado.gov on the tab labeled Proposed and Adopted Rules. Before we begin, a few more rules and guidelines for the record. In this hearing, the division is accepting oral testimony as well as written comments through the Zoom chat window available to anyone joining via the internet. The same administrative record will include all testimony, all comments in the chat window, and all written comments submitted outside this hearing. All testimony and comments are reviewed by the same division officials, including myself. So while you are free to comment or testify by whatever means you prefer, there is no need to repeat your points in multiple forms of testimony and comment submission. Written comments may be submitted in various ways. You may type them to Lydia Wologorski. You can submit them through the form on our website, or if they are short, you can just type them into the chat window in this Zoom hearing. The comment deadline is 5 p.m. this Friday, November 5th, 2021. This hearing is for comments related to the proposed rules. If instead you have individualized questions that you would like answers to, we would be happy to respond outside of this hearing. Email questions to lydia.wologorski at state.co.us so she can route you to the right person to give you an individualized response. We anticipate that the time available for today's hearing will be enough to hear all testimony on all proposed rules. Normally, public rulemaking hearings have a start time, then end whenever testimony is done or at the close of business. But given the broad interest in the matters of the family division being covered today, the division is aiming to accommodate testimony both by those best able to participate during business hours, as well as those best able to participate after hours. To that end, there are 3 scheduling points. We will be here until at least 7 p.m., even if testimony ends sooner, to see if anyone joins in the early evening. If by 7 p.m. any folks are still waiting to speak, we will stay later if needed. Given the length of this hearing and the number of folks participating who have participated previously in division hearings, I want to stress that there is no need to stay for the entire hearing. At least for division hearings that may be lengthy, most attendees do not stay for the entire hearing.
Thank you. With that said, is there anyone in the room that would like to testify or anyone that is here in person? Seeing none, we'll go right to virtual testimony. And we've had 19 people signed up for virtual testimony, and not everyone is here according to our attendance roster. And so I will call out 3 names. And so the first person will go, and then we'll have 2 on deck to go. So you have some time to know when you will be up. So let's go ahead and start with Jared Make, who is registered to provide comments. And then next up, if Judge Gallivan would like to speak, and then followed by Caitlin Tone. Thank you. Jared, whenever you are ready, if you want to unmute yourself and share your video, you're welcome to do so.
Hello, were you able to hear me?
Yes, thank you.
Okay, and it looks like there's no option to turn on my camera that I can see. So is it okay if I just proceed without that?
Of course.
Great, thank you. So good evening. I'm Jared Make, Vice President of A Better Balance, based in our Colorado office. I'll be speaking on the organization's behalf. So we appreciate all of CDLE's work on these rules, which we support overall, and would like to address 3 areas of concern today. So first, we have significant concerns with the complete omission of service charges from what counts as wages for premium assessments in Rule 1.5.3, B through D. It's clear that a service charge controlled by the employer and distributed to employees is part of an employee's wages in Colorado, including in Colorado's UI law, alongside tips and gratuities. The IRS has also issued guidance to employers stating clearly that generally service charges are non-tipped wages when they are distributed to the employee. In addition, a December 2019 blog post by the Colorado Restaurant Association provides helpful guidance and shows there's no ambiguity. They state, quote, service charges being allocated to employees should be treated the same as regular wages for tax withholding and filing purposes, end quote. Service charges controlled by the employer and distributed to employees should count as wages for FAMLI, just as under Colorado wage law, unemployment insurance, and tax law. There's no rational basis for treating service charges differently in this one program, and such omission will create confusion by providing a new description of wages not found in other state laws and at odds with tax rules. It could also underfund family benefits for many service industry workers. Next, I'd like to address Rule 1.5.2 regarding self-employed workers. To ensure a lack of barriers for self-employed individuals, including some contractors and non-employee gig workers, we urge CDLE to set up a default between either gross or net wages for self-employed individuals, rather than asking them to choose one when electing coverage. A default will reduce the administrative burden on CDLE and make it easier for self-employed individuals to participate in the family program and elect coverage with limited confusion. We otherwise support the language in this rule, which gives self-employed individuals the freedom to make a change from gross or net, depending on their preference. And this rule could be amended easily to allow the self-employed person to elect to change from the default. And next, I'd like to speak on enforcement. Rule 1.5.5c makes clear that violations may result in legal fees, fines, penalties, and debt interest accrual, but these proposed rules don't specify what penalties would result from premium collection violations. While the premium rules don't go into details about family violations, we wanted to acknowledge on the record our strong belief that premium violations must necessarily be included in future rulemaking on enforcement of the Family Act overall. And it makes sense for future rules on enforcement to include premium-related violations as one part of the law's overall enforcement and fine structures. And other Colorado laws like UI, paid sick leave, equal pay could all provide examples. But clear enforcement rules, including penalties to disincentivize employers from violating premium obligations, will ensure full compliance with FAMLI. So in addition to these concerns, we'd just like to close by voicing strong support for a few proposed rules, which we urge CDLE to adopt as drafted. We support Rule 1.5.1a, which correctly allows self-employed individuals to access family benefits soon after electing coverage and aren't subject to an unreasonable waiting period that would conflict with the statute. We also support Rule 1.5.6a, on the counting of employees for FAMLI's small employer premium discount. The proposed standard, also used by the federal FMLA and Colorado sick leave law, is the correct approach and one that's familiar to employers already. And then we support Rule 1.5.6C1, which covers localization of employment for family coverage. And by using the well-established Colorado UI standard already familiar to employers, this rule provides a fair and straightforward way to determine family coverage. And finally, we appreciate the drafting of Rule 1.6A1C. The rule as drafted promotes worker privacy and minimizes the potential for retaliation against local government employees who opt back into family benefits if their employer declines coverage. So thanks so much for the opportunity to testify today and all of your work on the proposed rules.
Thank you so much. Caitlin, I believe you're up next. And then after Caitlin, we'll have Scott Spindlove, if you would like to speak.
Hi, are you able to hear me?
Yes, we are.
Great. Thank you so much for the opportunity to testify. My name is Caitlin Altone. I am an organizer at 9 to 5 Colorado and coordinator for the Implementation Coalition. 9 to 5 has been leading on paid family and medical leave for over a decade, and we are so excited to be at the stage of bringing paid leave to Coloradans. My colleagues and I have spoken with thousands of workers who have been without paid leave, and the need for this program is deeply felt. The greatest burden for unmet paid leave is on women, especially women of color, and workers who are marginalized in multiple aspects of their lives. The FAMLI program will bring meaningful change to people's lives. We ask that you remember the experiences of new parents returning to work too soon after welcoming a child, the workers who continued working instead of taking care of their health, and the families who had to prioritize a paycheck over caring for each other. The foundation for an equitable paid leave program was passed by voters, and we see the rules and regulations process as important follow-through for delivering this goal. 9 to 5 Colorado is pleased overall with the proposed premium rules, and we thank the division for involving stakeholders throughout the process. Our one change request is including service fees and wages for tipped workers. Service fees contribute to many tipped workers' income, and exclusion risks tipped workers receiving less benefits than they are entitled to. Most tipped workers are already low-wage workers, and potentially undercutting them on wage replacement may bar them from taking leave or cause them to incur unnecessary financial damage. We urge you to incorporate this change in the final rules. Additionally, we ask you to continue accounting for a diverse range of access needs while building the website and other platforms workers will interact with to access information or program benefits. Please consider access broadly, including preferred language, the spectrum of disabilities, general audience reading levels, and limited or no access to technology or internet service. We appreciate the effort that has already been made in this area and ask that you continue seeking guidance. Thank you so much for your work and for your attention to the needs of workers. 9 to 5 looks forward to supporting throughout the implementation of this program. Thank you for listening.
Thank you so much for your comments. Next up, we have Kayla Frawley, and on deck, we will add Dorothy Jones if you're both planning to speak.
Thank you. This is Kayla Frawley, and I am the Manager of Policy and Advocacy at Clayton Early Learning. I'm hoping my son's movie in the background is not too loud and you can hear me. Clayton Early Learning is a hub for Colorado's innovative work in early childhood development. We're committed fiercely to the belief that healthy early childhood development offers one of the most powerful levers for ending inequality. And Clayton plays a leadership role in demonstrating what works in the early years and the positive impact that it has for children and families over the course of time. Clayton's 20-acre campus in Denver is the home of Colorado's only Educare school, which is a nationally recognized model supporting children from birth to age 5 and their families. Clayton improves the early care and education for thousands of young children birth through age 5. And throughout the state, through our Denver-based services, community partnership sites, and educator training and coaching. We impact systems change in Colorado and nationally through our research and evaluation services, our professional development expertise, and our policy and advocacy work at the state and federal level. Our direct service and systems change work actually impacts around 20,000 children annually. As a provider of quality early care, education, and family support, we appreciate the opportunity to comment on the drafting of the FAMLI premium rules. We appreciate the Department of Labor and Employment ensuring that rules promote fairness for self-employed individuals and small businesses and following the standards and language established in Prop 118. We appreciate CDLE's excellent work on premium rule drafting and would like to see the rules implemented as drafted, with one exception of critical importance. Proposed Rule 1.5.3. We believe proposed Rule 1.5.3 should be amended to use the well-established standard in unemployment insurance and count service charges that are distributed to employees in the service industry as quote-unquote wages for the purposes of FAMLI premiums. Considering this, we are requesting that proposed Rule 1.5.3 be amended to ensure that service charges that are controlled by employers and distributed to employees are counted as wages, which is actually the established standard for tax purposes and under Colorado's unemployment insurance law. We acknowledge that if FAMLI rules set a new standard for service charges by fully excluding them as quote-unquote wages, low-wage service industry workers in low-wage positions will be harmed and could ultimately receive less in FAMLI benefits. We acknowledge that this would negatively impact many low-income families Clayton serves and their family economic security. Therefore, it is essential that not only tips and gratuities, but also service charges controlled by the employer and distributed to employees are counted as wages for FAMLI premium calculations, just as done under unemployment insurance. We are also pleased to support CDLE's proposed Rule 1.5.1a on the timing of the election and coverage of self-employed people. The proposed rules state that self-employed individuals coverage will begin the calendar quarter after the self-employed individual has elected coverage. This ensures that self-employed individuals have elected coverage and are not subject to an unreasonable waiting period. Any longer waiting period beyond the administrative period proposed by CDLE to process self-employed coverage would be directly contradictory to the text of the law. Equally, we are pleased to support CDLE's proposed Rule 1.5.6a on the counting of the number of employees for FAMLI's small employer premium discount and believe the proposed FMLA standard, also used in CDLE rules on sick leave, is the best approach. We appreciate CDLE's work on this rule to ensure that small businesses receive the premium discount intended to support them and to avoid any loopholes that would unfairly benefit larger corporations and promote prejudice in the hiring of Colorado workers who may be viewed as likely to utilize FAMLI. The discount on premium payments for small business should not be dependent on the total numbers of employees just in Colorado, but the true total employed at the business. This approach will not affect the geographic hiring decisions of larger multi-state companies with only a few employees in Colorado. This is the last part. Additionally, acknowledging that Colorado is geographically very diverse, we fully support the localization approach in proposed Rule 1.5.6 C1. We appreciate that CDLE incorporates the existing localization model that is already familiar to employers and CDLE through its use in unemployment insurance pursuant to C.R.S. 870.117. Proposition 118 did not restrict its definition of employee or employer for family to those who are solely physically located in Colorado, which reflects largely contemporary remote COVID work conditions. We are thankful for the opportunity to submit comments and look forward to partnering with CDLE and 9 to 5 Colorado to ensure that Coloradans have equitable paid family leave. Please don't hesitate to contact me with any questions.
Thank you so much for your comments. Next up, we have on the screen, we have Christopher Garcia listed. We have someone listed as Jay Cares. Christopher, if you're wanting to provide comment, you can unmute. Provide comment.
Hello, my name is Christopher Garcia. Thank you for the opportunity to speak tonight. I myself have been an advocate for paid family leave for around a decade here in Colorado, and I'm super excited to see that this is finally becoming a reality. I have been a community leader with 9 to 5 Colorado and got involved in this project because I had to take my dad off of life support while I was at work because I didn't have access to paid family leave. And when I had my son, I did not want my son or now my 2 other stepsons to have to make those same difficult decisions that I had to make in 2009, taking my dad off of life support while I was at work. It took me nearly 6.5 months to recover financially because once I took my dad off of life support, I actually had to go out of state to take care of his funeral. And because it was a military funeral, it took over a week. And when I came back, I was also suspended from my job because I was gone past the bereavement time that was allotted. And that played a very important role in my decision to become involved and speak on paid family leave, because I don't feel that others should have to make those same difficult decisions of, do we need a paycheck or spending time with family? And this last year, the pandemic kind of really showed that. So for me, this rulemaking process is extremely important. As someone that's had a small business, you know, I would have loved to have had this when I was in business for myself. And as I'm considering opening up another business this next year, it's something that I look forward to being able to provide for my employees as well as I grow my business. So for me, being involved in this rulemaking process is super important because I want to ensure that we have an equitable program, which is what we fought for. And the community is definitely following this process so that we can ensure that it's what we envisioned. So thank you again for all your hard work on this this policy. We know that it's something that's very important and that's very needed here in Colorado. So thank you so much for listening to my comments.
Thank you so much for making comments. I have 2 more people that are in our queue that have not confirmed if you are wanting to make a public comment yet or not. Jay Cares, and I apologize if I've mispronounced that. It's Jcaires. you're with us and like to make comments, you're welcome to unmute and do so. And then on deck, and this is the last person that I have signed up in our queue right now, is Cindy Beslever. I apologize for if I've mispronounced that name. It's Cindy with 2 Y's. Thank you. And for the record, both of those folks have sent us a chat message saying they do not plan on making comments this evening and are listening in. Okay. Is there anyone else joining us virtually or on the phone that would like to make a public comment? Okay. We've committed to being at the hearing until 7. And so, for this evening. And so if anyone would like to make a comment or if anyone joins us, we'll be monitoring the chat. If you join us, please let us know if you'd like to make a comment and we will have you unmute yourself and allow you to do so. Thank you.